You're listening to the True North Success Podcast. Real stories of personal, professional, and financial wins from Alberta's best. With your hosts, Gary Ma and Amy Kim.
Hi, everybody. Welcome back to the show. Today, my special guest is Gary Kirk. Gary is a seasoned Alberta lawyer with over 25 years of experience in litigation and family law and wills and estates, mediation and arbitration. So he has appeared at all levels of court and participated in the 300 plus dispute resolution processes, while also contributing extensively as an educator and speaker and legal volunteer. It's a real pleasure to have Gary on the show today. Welcome, Gary.
Thank you, Amy. Appreciate you having me.
Awesome. So, Gary, I gave a brief overview of your success. Can you fit in the detail of what you do?
Yeah, so I'm at a stage of my career where I do more mediation arbitration as opposed to litigation. As an arbitrator or mediator, I'm the third party in the room who tries to assist the parties in getting to a resolution. And if they can't, then if they've authorized me, then I can act as a judicial decision maker and impose a decision. Now that's different from my role in the early part of my career where I acted more as an advocate, as a litigator, and I was advocating on behalf of the parties. What I've found over years of litigation is that the courts are a very blunt instrument. And if people can be encouraged to mediate their disputes, and my work is primarily in family and estate law, they may not be entirely happy, but they're generally much happier than if they have to go to court, where the processes are much more complex and frequently much more expensive.
Yeah, I think that's very true. I think the earlier that we meet together and then talk each other, I think to find out what's really looking for, I think much easier than go through all the court lengthy and complicated process. So I'm always interested in learning about the story behind. Could you share how you first got started in this field?
Well, I'll go back probably further than you were thinking, but I graduated from high school in the 80s. And for those of you who are old enough, you'll remember that Alberta was in a bit of an economic dumpster fire at that time. And I went to university. I got a basic degree in English. I thought I would figure out what it was that I wanted to do. And it just didn't appear. But in my mid-20s, I actually had some interaction with some litigation in my family. I met some lawyers, and I found that what they were doing was fascinating, which had never occurred to me before. So my mid-20s, I started getting ready for law school, made some applications, and the rest is history. I've been practicing law since 1998. Initially, I had a very wide, varied practice. I took basically whatever walked through the door just to keep the lights on. But as time went on, I peeled back various practice areas as I got busier and busier, and now working primarily in family and estate law. And those two areas have always been a portion of my practice, but now they're exclusively the practice areas that I have.
Awesome. So looking back, were there any key experiences from your work or over, that 300 plus dispute resolution cases in a courtroom and a mediation that shape your approach to helping people find the resolutions in the difficult situations?
Yeah, initially it was all about winning. It was very adversarial. And for most litigators, it still is, and that's not a bad thing necessarily. We have an adversarial system. But as I'd indicated earlier, I found that the courts, if I say they're blunt instruments, that's not a criticism of the judges. The judges are very busy. They don't have time, frankly, to get into the detail that most people expect. And if one file gets resolved, they've got a whole bunch more lined up behind them. And gradually, I came to realize that sort of kicking and screaming, I got dragged into some alternate dispute resolution process through mediation, where the courts mandated, at that time in the Provincial Court of Justice, mandated a mediation process prior to being allowed to go to trial. And I found that some cases in which I was acting as counsel, which I thought would never settle, in the hands of a skilled mediator, settled. And my clients were happier. We didn't have to go to court. People saved money. And that began to change my attitude. So about 15 years ago, I started to take training in mediation and negotiating and interest-based negotiation. And it slowly grew from a very small, I'll call it an alternate dispute resolution practice. It slowly grew organically to where it now forms the bulk of my practice.
Wow. Yeah. That's really inspiring. And then what was the one of the biggest challenges you had to overcome in your career?
Well, there, I suppose, been a few, but staying in that theme of shifting from litigation to alternate dispute resolution was for me to get over myself, for me to get over the idea that I or my client had to win at all costs. Certainly, you want, as a client, you want a lawyer who is going to advocate very strongly for you, but sometimes, to use a tired old cliche, you have to wonder if the juice is worth the squeeze, because sometimes you can spend a lot of time and money, and in theory you can win, but by the time you've spent 6, 12, 18 months of your life in litigation, spent thousands and thousands of dollars in legal fees, and then get a result that might be in theory a win, but in practice doesn't seem to accommodate what you thought you were going to achieve, it can be very disappointing. And my view is that people who are facing some sort of a legal dispute would benefit from getting into mediation sooner rather than later. The sooner the better, because often the disputes turn out to be not so much about money, but about relationships or about interests that aren't obvious, that a court cannot accommodate, but can be accommodated through a transparent mediation process. And if people can get their disputes resolved and go on with their lives, run their businesses, spend time making money instead of spending time in the courthouse, so much the better.
Yeah. Yeah, that makes sense. So I really can relate to that. A lot of times it's not about the money. I think more maybe emotional damages, or they still have some resentment towards angers, and I think they wanted to go to that the legal court, and maybe hoping to get some resolutions.
You're absolutely correct. And nowhere is that more true, I think, than in estate disputes where you have brothers and sisters or relatives fighting. It's very rarely about the money, and it's very often about problems in the relationship that go back sometimes decades. And again, in the hands of a skilled mediator, and there are quite a few. I mean, I do that, but obviously there are many who do that very, very well. And the other difficulty I think that people don't anticipate is just how long the court process takes. A lot of people are under the impression that if they file a lawsuit or if they bring a claim in court, they're going to have 1 or 2 appearances and it's going to be done. And that's just not the way it happens. The rules of court have very detailed processes to follow. The courts are trying to expedite and streamline. They do recognize that that's an issue, but it's and it is getting better, but it's still a long process, and it can be abbreviated dramatically through a successful mediation or arbitration process.
Right. I can only imagine that because especially people they're coming and working with you, they are hurt, they have a wound. So probably they when you working with them and helping them, is there any strategies that you want them like make sure that they feel heard and then they are willing to work with you?
Yeah. So I'll just pick up on the comment you made about people coming in feeling hurt. One of the things that I noticed earlier in my career is when people come in to see me or any other lawyer, it's like going to see a doctor. You've got something that's wrong. You don't know exactly what it is, and you don't know exactly what the cure is. And sometimes it's not good news, but at least knowledge, the knowledge makes people feel better. So if they can walk out going, okay, now I understand the law, now I understand what my options are, they feel better. It still may not be a great result, but it's better than the lack of knowledge that they walked in with. So I think, and this might be a bit of a cliche, but I think that at the core, the legal profession can be and should be a helping profession. Not to say that we're not going to make money and make a good living off of this. Of course, we are. But there's a lot I think we can do to make people to help fix their problems, particularly if they're being oppressed by someone illegally.
Yeah, that so makes sense to me. Do you think like when you grew up, so
Mm.
because like being a mediator, listening to people, finding some solutions that all parties can agree, it's not something very easy to do. So is it something like when you grew up,
Mm.
is it something you think that it's affected you how you grew up and then more able to listen to other people and then how you can help them better?
I honestly, I don't know. I had four older brothers that I fought with constantly, so I'm not sure that if that helped my fighting skills or my mediation skills, maybe a little bit of both. I will say that whatever happened in my childhood or my formative years, I seem to have found, I'll say, a sweet spot. I think although I did a lot of litigation and I like to think that I was pretty good at it, um, I honestly, I didn't really enjoy it that much. Acting as a mediator or arbitrator is something that I actually enjoy. So here I am, 28 years into my career. It didn't take me quite this long, but as I began doing more and more, again, I'll call ADR, alternate dispute resolution work, I found a more personal satisfaction in doing that kind of work as opposed to the contested advocacy litigation work.
Yeah, I can relate to that a lot too. Like, I love your story. So, what exciting plans or initiatives do we have coming up over the next 6 to 12 months?
Well, let me give a little plug for a new process at the courts because the courts have been bottlenecked. The complement of justices has always been undersubscribed because of delay in the government in appointing justices. Funding has not been great. And litigation, particularly family and estate litigation, is blowing up. Estate litigation, because in part of the demographic bulge, that is, as the baby boomers are aging out and frankly dying, their estates have a certain amount of money, and that leads to litigation. And also the family end of things, it always seems to be busy. And so then speaking particularly about the family end in the courts, so this is less in terms of what I do, but for people who have family disputes, the courts have introduced what's called the Family Focused Protocol. It was introduced in January, and it's going through a few hiccups, but it's getting streamlined. It requires parties to go through a very clear process of financial disclosure and attempting alternate dispute resolution before they can actually get into court. Now, again, there are some hiccups going on right now in terms of getting this process worked out. I think it's going to be beneficial in the long run, and it's designed to get people into court in front of what's called a management intake justice, who will then act as a mediator. And I think that once this gets going, a lot of people, especially when they have the gravitas of a Court of King's Bench justice, look at their file and giving them advice, it's going to get a lot of resolution much faster. Now, it does still take time, and there are some instances where that process may not work, and that's where people in my role can still assist people outside of the court process if they need something faster or quicker.
I see. So could you tell us a little bit more about when you say that there's a now new system is already introduced and there's still hiccups, but they need to provide more information before they start their court. So and then previously they can just start with not enough information, or how does that different now?
Yeah, so one of the biggest problems in family law has always been and continues to be lack of financial disclosure, where one party is, for various reasons, very often deliberately withholding important financial information, which then makes it difficult for people to make decisions in terms of their property division or what should be paid for spousal support or child support or expenses. So one of the most important things that's coming out of the Family Focus Protocol is that financial disclosure has to be provided before people can get into court, or they get a waiver. If one side is simply not being cooperative, they can get a waiver, but that will then assist in people making informed choices if they are able to resolve it either directly or with the assistance of a management intake justice. Frankly, that's useful in any kind of mediation. So that's one item of several, but I think it's one of the most important items. The parties are also required to take what's called a parenting after separation course. Now, they've always been required to do that, but these are things where the court is saying, look, unless you guys get these things done, you cannot get in front of a judge except in an emergency. So it will motivate people to do the things that they may have been delinquent on before, and then put them into have a single justice that they appear before on a regular basis, and have benefit of a mediation with that justice, which was not the case before. And as I said, we're just at the beginning stages of this. I think that within a year or so, we're all going to look back and say we should have been doing this for a long, long time.
I see. The one other thing that I was wondering about, because I went through divorce, and like my ex was willing to disclose all of his financial as well.
Yeah.
And at the end, because he didn't disclose all of this, so based on what he disclosed, the judgment was made, which wasn't very working good for my side, because I disclosed everything. So then he didn't get any consequences. Actually, he got the benefit by not disclosing everything. So how the court can do better?
Yeah. So your point is well taken. The courts have described lack of financial disclosure as, quote, the cancer of family litigation. So the Family Focus Protocol is a response to require people to provide those items in advance. If they don't, the court can, or a mediator or arbitrator can impose what's called an adverse inference. So if you're supposed to provide your income and you don't, then the court can simply say, okay, we're going to set your income at a certain amount. And you may not like that, but that's the consequence if you don't provide this information. So that was a remedy that was available before, but I think it's going to be imposed more regularly as we'll just say a crowbar to move people to do what they're supposed to do, so that let's just forget about spousal support for a moment. Let's just talk about child supports, that the children in families of separation or divorce are receiving adequate amounts of support.
Yeah. Okay. Yeah, makes sense. Okay. So, okay, hold on. So, yes. Sounds like you're doing really good, and you're for your careers with all the experiences. So congratulations. And maybe we are talking about a little bit. We're going to switch a little bit topic over the financing and work-life balance. So many professionals are earning strong incomes right now, but it often requires significant invest of time and energy. So looking ahead, a common goal is to maintain that same level of income and lifestyle while working maybe perhaps less and less, especially with the inflation at all-time high. So as a result, many people are exploring ways to generate income outside of their primary work. Sometimes like investing in stocks or cryptocurrency or precious metals or real estate. So what are your thoughts about income outside of work?
Well, if you can generate passive income, and I'm not a financial advisor, but if you can treat your primary source of income as the engine that drives the money-making car, so to speak, but also have assets or investments that create passive income, that creates a certain level of security. Certainly, my view and my practice has been, the law practice, what I do on a day-to-day basis, is the most important thing. And so that's what I prioritize. Now, as my practice has evolved over the years, if I say I work less, I still work a lot. When I started, I worked quite a lot. That's a bit of a cliche in the legal industry, but frankly, in order to get the experience that you need to be successful, I think you have to work a lot. You have to get a lot of experience. You have to go to trial, go to court. And this assumes that you follow the path I did, which is going to court, because obviously there are lawyers who do solicitors work or who work in-house or work for the government where court work isn't a necessary part of it. But if you're going to be going to court, I think the more you do, especially early on, the better, because that then creates knowledge, which becomes an asset that can be leveraged to make more money as you go forward, or to be more efficient as well. And there have been times when I made very little money on files, but I got a lot of valuable experience, and I just considered that to be worth the time and money because it assisted me going forward. But to the extent that anybody can take their excess earnings and put that into an asset that either grows through the growth in equity, growth in value, or spin off income, that ideally is the way to go also.
Awesome. I love that. So as we wrap it up, what advice would you give to individuals going through, family or estate dispute on how to better navigate a conflict and decision making under stress?
Well, I would say do as much work as you can. Obviously, yes, you mentioned the work-life balance. You don't want to ignore that entirely, and you also don't want to get burnt out, which is a risk in law as well. But it's important, I think, to the analogy I use is if you're going to be a doctor, you need to see a certain number of patients, do a certain number of operations in order to become skilled and get the knowledge. And it's similar with being a lawyer. So the more files you can work through, the more experience you're going to have, and the more efficient you're going to be. So I will say it's a bit scary. The first few times I went to court, I felt like my heart was going to jump out of my chest. But I survived, and you gain skills. So I think it's important to get those skills, and then as you acquire those skills, then it's easier to sit back a little bit and say, how do I want to focus my practice? Do I want to specialize? Do I want to stay a generalist? And plan your career from there.
So your advice was more someone who wanted to get into the field that we're practicing the mediation and then helping finding the solution in the middle. But what about the individuals who are actually going through right now, family and estate dispute, and how to navigate those conflicts and making decisions under stress, like doesn't know where to start. So how to find is a good lawyer to work with?
Well, yeah, I think the first thing is to consult. Now, in terms of finding a good lawyer, that might be a matter of inquiring with friends who've had similar experiences or going online. And I think it's worthwhile to speak to more than one lawyer. Just because one lawyer has a bunch of good reviews, sometimes it's not a matter of skill, it's a matter of the personal relationship and how you connect or communicate with your lawyer or with your client. And so making sure it's a good fit from that point of view, I think is important. And then gaining the information and then making at some point, what I'll just say is a cost risk analysis. How much is it going to cost me to get the answer from the court, and what's my potential benefit? Is there a way for me to get a result that I can live with, but without spending all of my disposable income and my savings on it? And I'm being a little bit extreme, but sometimes that's the case. And then making a decision. Sometimes you have to go all the way to trial, but I would say easily 90% of all disputes can be solved short of trial.
Mm-hmm. Yeah, I love that. That totally makes sense. I've seen people around me that they spend, that cost equal to almost like a good, car, Lamborghini. Mm-hmm. They say after they settle everything, and then they added to spend the money on almost the cost of the Lamborghini.
Yeah, I was going to say Lamborghini or Ferrari, not Not a starter car.
Exactly. Yeah. Awesome. Yes. So thank you so much, Gary, for your time today and sharing some of your great insights and inspiring story with us. Is there anything else would you like to share with us before you go?
No, I think you've covered it, Amy. Thank you for having me. I appreciate it, and I've enjoyed it.
Awesome. Okay. So if people would like to get a hold of you, how can reach out to you?
Well, they can just do a search on my name or on our law firm, Kirk Montoot Dawson,
Mm-hmm.
and we'll pop up probably on the first page. And we have an online portal where people can submit requests for appointments or calls.
Awesome. So we truly appreciate your time, Gary, and then the perspectives you brought to the conversation.
My pleasure. Thank you, Amy.
Want to share your success story? Apply to be a guest at truenorthsuccessshow.com/guest. We'd love to hear from you.